guest today. We're excited to have Jeff Rowley, our claims manager here at the Trust, to present on the topic of notices of claim and new claim tools. Jeff is a fairly recent arrival here at the Trust, but he comes with a wealth of knowledge and a long history of working with local government agencies and risk management and claims, and he's a pleasure to work with. So we're happy to have Jeff here today to present on this important topic. Jeff, do you want to go ahead and take the screen?
Thank you, Jason. So again, I'm pleased to be here. Sorry for the technical difficulties, and I will just jump into my presentation. In the 9 months I've been here, I've had an opportunity to meet or at least talk with several of you. Many Trust members, I haven't had that opportunity, and in truth, that's not a bad thing. If you don't know the claims manager, things are going probably pretty well in your organization. So we'll try not to meet under those circumstances at least. I chose this first picture that I took on July 4th to start my presentation for a couple of reasons. First of all, this was a nice event where they unfurled this big, beautiful flag at the base of the canyon with music and a choir and stories from the military, and it was an awesome experience, reminding us of how wonderful our country is. And then halfway through the presentation, we suffered a downpour and had to leave early because my granddaughter was freezing. And I was thinking about our communities who are here in Utah, which is a desert during the middle of a drought, have of late suffered significant flooding events. And we want you to know that our hearts and concerns are with you and recovering from those events. But also, I present this flag here just as a primer to the topic today. And we became a country after we left England and other countries, left because we wanted to get away from monarchy and the tyranny of monarchy to create our own governments. And one of the principles of a monarchy, now my screen won't advance. There we go. Yeah, is that the king can do no wrong. In other words, not only can the king break in and check out your personal belongings, which was something that our ancestors didn't like, but also you couldn't sue him over any damages that he caused. And so we have filtered that down to what we now have is the governmental immunity, or for Utah, the Utah Governmental Immunity Act, which doesn't make the government free from any responsibility from everything, but it certainly limits it down where you can't sue for some things because government does what it does because private citizens can't do it, or because it takes the funds from the entire village to pay for some of the operations we do, or because the liability would just be too great for anybody else to do it. And so we have the Governmental Immunity Act to protect us as government entities, and we operate under it. The Utah Governmental Immunity Act has essentially three elements to it. First, it acts like a picket fence in the courts, meaning that there are certain things that you just can't sue the government for. It's like government is behind the picket fence, and some things that people may want to sue government for, they just can't because we're immune for it. Secondly, it provides a limit as to how much you can sue the government for. Currently, the limit is $3 million for injuries to more than one person and down to $233,000 if it's just a property damage claim. So you can't sue the government for certain things. You can't sue it for more than a certain amount of dollars, or that is reduced in court to the limits that are there. And thirdly, it provides a pathway into the claims process in the court system. Now, the Trust has been following vigorously ever since its origins with the immunity and not paying where the government is immune, and applying the limits. But we've been a little bit less vigilant in the pathway into claims against governments. And so we haven't been taking advantage of the protections that come with that. And I'd like to talk about that today. And we believe that now is the time for us to move ahead and take full advantage of all three of these elements of the Governmental Immunity Act by engaging in the notice of claim process. And so for the bulk of the presentation, I will explain the notice of claim process and how we want to do it here at the Trust. We'll start by talking about the law that's complex as any statutory scheme is. Then we'll talk about why the notice of claim process, why it's important, how it helps us. And then we'll talk about why now, why we're implementing this change at this time. And then finally, we'll talk about the actual implementation, and we'll move from the complex to the simple as we talk about implementation. Well, to start off with the heavy stuff, the law, the pathway into making a claim against the government is prescribed in the Utah law under the Governmental Immunity Act, which is found in Title 63G, Chapter 7. The notice of claim process is in Part 4, and it says in part, any person having a claim against a governmental entity or against the governmental entity's employee for an act or omission occurring during the performance of the employee's duties within the scope of employment or under color of authority shall file a written notice of claim with the entity before maintaining an action. So before maintaining an action, the gateway in there is and shall be filing a notice of claim. Well, what is a notice of claim? Well, it's nothing secret. There's nothing hard about it. It's just like filing any kind of a claim, whether you're a homeowner claim, an auto claim, a warranty claim. There's certain bits of information that need to be gathered in order for the party you're making a claim against to know what the claim is about and what they need to do about it. So let's talk about the elements of the notice of claim as prescribed in state law. We'll talk about the what, the who, the how, and the when. For the what, the notice of claim shall set forth a brief statement of facts, the nature of the claim asserted, the damages incurred so far as they are known, and if the claim is being pursued against a governmental employee, the name of that employee. That is almost everything that needs to be included on a notice of claim. It's not very much. Again, it's not very detailed or a mystery in any way. Well, here's the who. The claim must be signed by the person making the claim or their agent, their attorney, whatever. So because it must be signed, of course, the notice of claim has to be written down, made by the person who's making the claim. In my career, I've seen several times where people have made claims on behalf of others, and that just doesn't fly. For instance, if a friend borrows a car and he hits a pothole, the friend can't make the claim on behalf of the owner of the car. It has to be the owner of the car making claim for their damages. And then the claim that is made has to be delivered, transmitted, or sent to these individuals and these types of entities. For cities, towns, and counties, it can be the clerk, or for a city, it's often a recorder. For a local or special district, to the presiding officer, the secretary, or the clerk. For a public board or commission, a member of the governing board, the executive director, or the executive secretary. And then any public entity can designate somebody other than these officers in their organization as their designated agent. And we'll talk about how to select your designated agent. How is a claim to be made? The notice of claim shall be delivered by hand, delivered or transmitted by mail to the designated persons, and that was by US mail, or sent by electronic mail to the addresses provided. Even if it's sent by email, it has to go to the designated agent and to the attorney for the entity that the claim is being brought against. And then the when. Under the Governmental Immunity Act, a claim against a governmental entity or against an employee for an act or omission occurring during the performance of the employee's duty within the scope of employment or under color of authority is barred, or in other words, stopped, can't even go, unless the notice of claim is filed with the person according to the requirements within 1 year after the claim arises. And that 1 year is when the claimant knew or should have known that the damages that they incurred are from a public entity and which public entity. And so they have 1 year to file the claim. So there's the what, the who, the how, and the when as provided by the statute. So the question comes up, so why are we changing our recommendations, our procedures right now and requiring a notice of claim? And why is it that we're doing that right now? So let's talk about the why. The courts have opined as to the value of the notice of claim process. They have said in a case from 2002 that the primary purpose is to afford the responsible public authorities an opportunity to pursue a proper and timely investigation of the merits of the claim and to arrive at a timely settlement, if appropriate, thereby avoiding the expenditure of public revenues for costly and unnecessary litigation. And so a big reason for the notice of claim process is to give us the opportunity to manage a claim and settle it before it gets to litigation, but also to investigate it and to address any issues that are there. Now, if we were in person, I would say, can any of you come up with any ideas of scenarios where you might need to know where exactly it is and where it'd be helpful to have a notice of claim? But you can see it in front of me here. So obviously, entities that have streets, you got to know where that pothole is. And you have to know if the street that pothole is on is yours or the county's or the state's. I've seen many claims where people say that a public entity damaged them because one of their large trucks drove down the highway and threw rocks all over their car. Well, many public entities have large trucks driving with rocks in the back. So which truck was it? What time was it? Where was it? So you can identify if it was your truck or somebody else's. We recently received a claim for an incident that happened on a member's rodeo grounds. The member learned about the accident on the day that it happened because somebody told a volunteer, hey, a person was injured over here. That's pretty much what they knew. They didn't know if that person was the bull rider and they were injured when they were thrown off the bull. They didn't know if it was a problem with the facility. They didn't know anything other than what was told to the volunteer, which was very little. And so that was a perfect opportunity for a notice of claim to be filed to identify exactly what the problem was so that the member can get out there and fix it and prevent further problems or injuries to anybody else on their rodeo grounds. Also, the notice of claim is what's called a threshold requirement for the courts. In other words, it's the gate for getting into the claim and the lawsuit process. The court has said, importantly, compliance with the Governmental Immunity Act is a prerequisite to vesting the district court with subject matter jurisdiction over claims against governmental entities. So in other words, where the notice of claim process isn't followed, the governments can raise the defense that, hey, that process wasn't followed, therefore the court doesn't have subject matter jurisdiction. The case needs to be dismissed before there's any time or money spent on defending it, doing all of the depositions and discovery work. It saves costs, it saves time, because the government didn't have the opportunity to have notice and address the issue in advance. The courts have also said that without strict compliance with the notice of claim process, the courts lack authority. So it's not just a willy-nilly process. All of the elements that we've talked about need to be met, which sounds difficult, not just for a public entity, but also for anybody making a claim. But we can make that simple for you. Let me give you an example of a case where my employer at the time was saved from expensive litigation because the notice of claim process wasn't filed. Back in the 90s, which seems so long ago now, Salt Lake City had a pipeline, 16-inch pressurized pipeline coming straight out of Pardis Canyon. It traveled along the hillside above some very expensive homes on the east side under a trail. The pipe had been in the ground for 50 plus years and they had not had any problems with the pipe, had inspected it as much as you can, a culinary water line, which they had opportunity to do that in the wintertime when that line was shut down, and they hadn't found any problems. Well, one spring day, the pipe burst, sending a rooster tail of water down the hillside. That water collected mud and created its own canyon as it went, and the water was channeled by the rocks in the environment straight at a home just below it. That home, fortunately, was a steel-framed home. Water entered through a breezeway into the basement, filled up at the front of the house, blew out the front door of the house, and continued on the street. There was so much water and mud that the main floor, which consisted of a living area on one side and a pool above the garage on the other side, filled up with so much mud that in the pool area, you couldn't tell the difference between where the deck was and where the pool began. There was feet of mud in this poor house. Well, the city came up there and wanting to be good stewards, they helped as much as possible. For several days, we cleaned and helped this homeowner, but he was so upset at the city that one day he just said, I want the city out of here. I don't want to talk to you again. I've got an attorney. So we left and we expected a claim to be filed, even though we knew that there likely was absolutely nothing the city could have done to prevent this loss. And as it turned out, that with engineering studies, there's no way the city could have known that there was a problem with that pipe. Well, a year and a half later, a claim came in from the attorney for this man's insurance company. His attorney had not filed the claim. His insurance company had not filed the claim. He was barred by the statute of limitations, could not file a claim because he'd missed it. Now, was the city responsible in that case? No. But the city would have had to pay expensive litigation costs with frustration and all the time that's involved with that. But it was avoided because the city followed the protections provided by the notice of claim process in the Governmental Immunity Act. So on the other hand, where we handle claims without a notice of claim, we are barred from claiming that they haven't followed the notice of claim process. There is case law that indicates that if a government entity enters into negotiations, and certainly could be the case that if we string somebody along as if a claim had been filed properly, that the government entity would be barred from using those defenses. And so using the notice of claim process in each case is the best way to protect the entity and take full advantage of the Governmental Immunity Act. So why now? Well, the Governmental Immunity Act is attacked just about every year in the legislature by the plaintiffs' bar, and there are several in that bar who are members of the legislature, and usually they're attacking it to try and take away the protections the government enjoys. This last year, though, or this year in our main session, a bill was raised and passed through that was a little bit different, and I think finally provided an opportunity to move the Governmental Immunity Act into today's world, the 21st century. Before 2021, a notice of claim had to be delivered and could only be accepted if it was delivered by hand or by US mail. Well, who does that these days? So with the 2021 change, now the claim can be delivered by email as well, at the speed of the internet, just so long as it's received by the designated agent and the attorney for the entity receiving the claim. So that begs the question, why did it take so long to get here? But also the question, well, how does anybody know who is supposed to receive an email when a claim comes in? As part of the Governmental Immunity Act, there is a database that's housed within the Department of Commerce that each public entity is to file who it is that is to receive their claims. And as far as I can tell, all the members that I have worked with have a listing in this database. It looks like this. Some of them have been out of date and needed to be updated. But with the change in the law this year, now we need all of us to add our legal counsel, their name and their email address, so that a claim can be emailed into your entity. So we'd encourage you to do that, to take that step, and I'll talk to you about how you do that. It's a pretty simple process, but by updating it, now you can accept notices of claim by email. Things can get rolling much faster than they could be when it had to be delivered by hand or by mail. So we've talked about the complexity, and now I'd like to move on to the simplicity on the far side of complexity and show you how the trust has worked hard to make this easy for our members and for the public that we serve. Here's the process that we recommend for each of you. First, create your own notice of claim form that meets the elements. So it would need to have instructions where the claim needs to go, perhaps how long it is you have to file a claim, and those elements that are in a claim that need to be filed. Or after this presentation is over, we'll be sending out an email with a draft notice of claim form that I'll show you in just a moment that you can adopt and make your own. Then once you have that form, you can send that form out to any individual or entity that you've caused damage to and you expect a claim to come in, or if somebody calls you asking, how do I make a claim against you? Just forward that claim to them. They would then mail it back per the instructions on the form to you, and then you get it to us. Now, just a note, you don't need to send a notice of claim form out to an insurance company or to an attorney. Usually they have their own forms and they don't want your form. But if one of those entities calls you and asks, well, how do I make a claim against you? Just send them to the trust. We will guide them through that process, but you don't need to deal with that. Then when a claim comes in, whether it's fully compliant at the time or not, go ahead and send it on to us. Email it to the trust. And I'll talk about that in just a minute. As a reminder, while we're here, if you have a claim where somebody's represented by an attorney, please don't talk about the merits of the claim or anything about the claim with the individual unless their attorney is present. And even in those cases, it might be wise not to talk to them. We don't want to violate attorney-client privileges. So just a quick reminder there. Here's a sample of the claim form that we have made for you. It provides instructions. There's a spot on the page, on the cover sheet there, with a mailing envelope to make it very clear if you're mailing it in, this is where you go. Also, you can put in there the email addresses for your designated agent and your attorney. Just put them right on there so they know exactly where to send it. You make the form yours by putting your entity logo, name, and address on the header. And then there's 2 pages of the claim form itself. There's the first page and the second page. Now, you don't have to limit the claim form to just what's in the statute. As you can see that here, there's a few more questions that are very helpful in managing any type of claim. But if there's something in there that might be helpful for you, for instance, if you run clinics and it's helpful for you on that to know who it is that's the actual patient at your clinic, put the question on there. Who's the patient that you're here to see on the form? Make it your form. You can modify ours. You can use your own. But they're pretty simple, and then send that out to anybody seeking a claim. Then, as far as updating the Governmental Immunity Act database, it's pretty simple. First, designate your officer, and I think all of you have already done that receives your claims. Then send an email to Valerie Stewart. Valerie's a very pleasant lady who works for the Department of Commerce, and you can see there her email and address, phone number are provided for you. Provide her with your entity name, the name of your designated agent, the address for the designated agent, and the name and email address for your agent and for your attorney. She will then put it on the website like we saw before, and you're up to date and ready to go. And then, of course, remember to update the database when you have a personnel changeover. Now, we're excited to report this morning that we have some new ways to report incoming claims. And these are not just liability claims. This would apply to all the kinds of claims that you have. For instance, as you can see there, we now have an email address, and you might be looking at that email address and saying, that is the longest email address you've ever seen. And it is pretty long. We tried to shorten that down for you, but there are some domain legal issues where we couldn't get that shortened down. So at the end of this presentation, we'll be sending out to you a V card that if your email system or contact system will accept it, you just download that and then you can send it out to that contact, or you can just create your own so you only have to type that long email address in one time. The beauty of using this email address, especially with a notice of claim situation, is you can just scan it if it comes by paper, or if it's emailed to you, you just simply forward that email on and away you go. You've done everything you need to do. Also, that email address and the phone number below, which is a brand new phone number, both of those go to a team at CSS, the company that manages the claim under contract with the trust. That goes to a team of people that all they do is enter claims. And they recognize that that phone number and that email address are coming from people who are members of the trust. And so you don't need an account number. They will recognize that you're a part of the trust right away and get the claim put in for you. There is still the option of going onto our website and putting a claim in that way through the CSS system, which has been available forever. Using that method, you will need the account number that's listed there, and you should be familiar with that if you've had any claims. But I am excited to report to you that on August 30th, the look and the functionality of that page will be updated to make it much more user-friendly and logical in the flow of the process, and hopefully make it faster for putting things in that way. As a final note for reporting claims, if you have a crime claim, meaning your property is stolen, or cash is stolen, or you have an employee theft situation, or a cyber claim, or a pollution claim, please just report those to me directly, and I will help you get the process started.
Jeff, could we do one quick clarification here? We had a question asking, is Valerie's email address missing a T? Maybe if you
No.
a couple of slides if we're missing a letter.
Right, I wondered that myself. Because it should be Valerie Stewart, but it seems to me the state has just sort of a limit on the length of the name. So I've emailed her with that email address, and it should work.
So that's correct. Okay, great, thanks.
Yeah, that bothered me for a while too. So some of you may be thinking, well, okay, right now and up till today, we've just been calling in a claim and everything's good to go. So the notice of claim process seems to equal delay. And of course, delay is bad. I mean, if you have a car accident, and somebody needs a rental car, you don't want to wait for them to submit their claim before you can get them in a rental car. That's just not right. That's not good practice. Or a sewer backup or a broken water line that causes damage. Or if you happen to have a wallet stolen because a couple of teenagers at your rec center convinced your staff members that this was their locker, they lost their key and they need to get home in a hurry. So the staff member opens the locker and walks away. But really the locker belonged to somebody who looked like they might have a bit of money, and the teenagers saw that and created a heist. Or perhaps you have lent out or rented out your rec center for someone to have a wedding on your beautiful lawn next to your pool, but a staff member forgets to turn off the sprinklers. And so water sprays onto the sound equipment, right through the wedding cake, and ruins everybody's clothes. Those things have happened. I've been through those kinds of claims. And so you want to jump on those things quickly. You don't want to wait for a notice of claim to come in. So we have a process. We want to make this simple for you as well as for the people that you serve. So here is how we handle urgent matters urgently. First, gather what information you can and call the claim in to that new 844 number. Again, that number is dedicated to trust claims, and they will put the claim in for you. At the end of that process, you'll get a claim number. Provide a notice of claim form to the damaged party. Inform them that they need to submit the claim form, but that the claim has been submitted and underway, and that they should hear from an adjuster. And then give them the claim number and the number to CSS, which is that 800 number. If an adjuster hasn't been assigned, they will reach to a staff adjuster who can start the process rolling. If an adjuster has been assigned, they'll get right to the person that'll handle their claim from cradle to grave, and they can get the process rolling, getting a rental car going. Also, if it's a water claim, if we can get it in there early, in other words, if they let you know that there's been damage right away, the adjusters can actually talk to the homeowner and say, look, we can bring somebody out, a disaster restoration company, to help you out with it. And if we assign them to come out, we will pay the bill and guarantee their work that they do. So that's a great way. And a lot of people prefer not to be on the hook for the bill for that, but we have to get to that very quickly. So it's a good time to call the claim in. And then the claim will be processed, but it won't be ultimately settled until that notice of claim form is received. So they don't have to deal with that during the emergent times of a new claim. I hope that makes sense, and that process should make it very quick and easy, not just for you, but also those that are damaged. Now, if I could just shift gears real quickly to a couple of other new claims tools that we have available for you. First of all, for auto claims, that means damage to your autos or damage to the public that are damaged by you. There's an app for that. When a claim is made, the adjuster will ask you if you would like to use an app to estimate the damages. Now, the app works for all vehicles except for the largest, such as dump trucks, cement trucks, back trucks, those sorts of things that are pretty unique and not just generally out there in the marketplace. But for your pickups on down, you can use this app. You'll just need the claim number and your name, and then they'll take you in there. They'll recognize the kind of car you've got. You just follow the steps by taking several photos. The app, once you've submitted it, will prepare a preliminary estimate that a live person will then review. And often same day as you put it in with the app or the next day, you'll get a finalized evaluation of the damages and an offer for a payment in that amount. So it can go very quickly if that app is used. Finally, for damage to your buildings or damage to other people's property, if it's under $25,000, we now have a video option where instead of waiting for a damage adjuster to come out to your building or to somebody's home that has been flooded, they can set up a conference call where they just do a video chat. And they walk around with the phone in hand, showing where the damages are. The adjuster can take screenshots of the damage, can estimate sizes over the phone using some technology that they have. And again, using that process, an appraisal can be done and resources can be allocated for cleanup, for initial remediation right there and then using the app. So it's a quick way to assess damage both for vehicles and for your property. So a couple of great tools there. Also, in an upcoming presentation in a couple of months, I will also be sharing some other resources that we are going to be mounting onto our website under the claims page that will help you in all kinds of things, such as finding resources right away: doctors, pharmacies, hospitals, remediation contractors, towing companies, repair yards, those kinds of things. So we'll have those tools up and running, and we'll explain those next time. Well, that's what I have. I didn't really take very many breaths, so if there are questions, it's now time that would love to entertain those.
So folks, if you've got any questions, go ahead and type those into the chat box, and we'll see if we can stump Jeff on the questions. Great presentation there. I think that's good material. Maybe a little bit different angle than a lot of our members have maybe taken in the past, and so I think it's great information to share that way. I'm just looking for some messages.
Well, and I'm happy to take calls. My phone number is there if you have particular questions or concerns about the notice of claim process. The adjusting staff has been trained to tell people they need a notice of claim. So they may be calling you, your claimants, to say, hey, do you have a notice of claim form that I can fill out? But they've also been trained to not, just stop a claim or not handle it if a notice of claim is not received during this transition period. So should be a good way to go.
That's great. I really expected a lot of questions on this. We have some thank yous coming in the chat box there, but I'm not seeing any questions. So outstanding.
One last thought, just a reminder that there will be an email coming out after the presentation with a draft notice of claim form to make your own, with the V card for where to email or who to call if you have a brand new claim. Also with that, there is a white paper that we've prepared that explains the notice of claim process and its value to public entities under state law. So you'll get those 3 things in an email shortly.
Yeah, we'll email that to everybody who has signed up for the webinar today, along with the link to the recording for this session as well, if you want to go back and review that or share that with somebody else in your organization there.
Sorry about the technical difficulties. It's not often you get a cheat by looking at the presenter notes.
I thought it was great. Sorry, folks, that we had that. I promise you, it worked perfectly. We tested it ahead of time, and for some reason that happened. But that was absolutely okay. And just some kudos on there. Matt says Trust always done an amazing job helping an organization handle claims. Thanks, Jeff and the Trust team. Anyway, lots of good kudos there. Thank you, folks, for taking time out of your day to attend this webinar. Thank you, Jeff, for presenting it. And everybody go out and have a safe day.
Thanks, everybody.